If members would take their seats and our guests, we appreciate everyone being here. The subcommittee will come to order. Before we begin, I'd like to remind our guests in the audience the chair is obligated under the rules of the House and the rules of the committee to maintain order and preserve decorum in the committee room. The chair appreciates the audience cooperation in maintaining that order. Good morning and welcome to the Subcommittee on Communications and Technologies hearing on the uncertain future of the Internet. Tomorrow, the Federal Communications Commission is expected to adopt an order that may not ultimately provide net neutrality protections for American consumers. That might lay the ground for future regulation of the Internet, that may raise rates for American Internet users, and that could stymie Internet adoption, innovation, and investment. This order may be the salvation of edge providers that fear speculative ISP practices, or it may be the beginning of regulation of all platform providers wherever they sit on the Internet. We just don't know, and it doesn't have to be this way. Let's take a moment to point out that Chairman Upton and I ask for this process to be more open than is usual. We ask the chairman of the FCC to release the draft order, the rules and the jurisdictional arguments for the rules before the commission vote, so that people could really understand what they were getting themselves into. I recognize that it is not customary for the FCC to release its document before a vote. But then again, it's not customary for an FCC proceeding to attract the attention of an HBO comedian or scores of protesters and cat mascots parading in front of the FCC and Chairman Wheeler's Georgetown home. Nor is it customary to have the President add his weight to steer an independent agency's decision. Our calls for transparency have been echoed by others to no avail. In short, we are still in the dark on net neutrality rules, and we don't have to be. Uncertainty is what we hope to stave off by introducing legislation that would clearly demarcate the FCC's authority over the Internet. Most of you know I did not see the need for net neutrality rules, and some of my colleagues had to be dragged kicking and screaming, quote unquote. We came to the table toward our draft bill. Thanks for that remark, John Shimkus. Despite our reservations, we came to the table with legislation for two reasons. The first is that not one of us disagrees with the four principles adopted by the FCC in 2005. First principle being consumers are entitled to access the lawful Internet content of their choice. We all agree on that. Number two, consumers are entitled to run applications and services of their choice subject to the need of law enforcement. Three, consumers are entitled to connect their choice of legal devices that do not harm the network. And four, consumers are entitled to competition among network providers, application and service providers, and content providers. The Internet has been a catalyst for our modern information economy and culture precisely because of these guiding principles. But the current draft order, which will purportedly subject the Internet to monopoly-era regulation under Title II of the Communications Act, threatens to throw all of this out the window and to generate significant uncertainty that will impact the industry, its investors, and ultimately its consumers. Accordingly, the second reason that we've offered legislation is to quell that wave of uncertainty. No more trips to the D.C. Circuit for the FCC, at least on this issue. Our economy and our communities are better served by ISPs that can invest in services rather than in lawyers. We're all better served by an agency with clear jurisdiction rather than one that engages in policy making by litigation. I think this is something everyone would support, but I've yet to find anyone willing to engage in a real negotiation over what this bill should look like. I'm not above asking again. So let's talk about how we can work together to solve the problem and end the uncertainty. The door remains open. So today our hearing is intended to lay out some of the questions we've been asking and to explore the uncertainty surrounding these new proposed rules. Our panel of witnesses today contains several veterans of this debate. Mr. Boucher, in particular, welcome back. You sat right here in this very chair with a gavel that looked a lot like this one when the FCC began its first attempt to enforce net neutrality through regulation. It's very good of you to return to talk to us about this same issue today. I hope that all of us here in the room will continue to engage in a productive dialogue and use the tools at only our disposal to end the net neutrality debate once and for all. I now recognize the gentlelady from Tennessee for the remainder of my time.
Thank you, Mr. Chairman. I want to welcome each of you here today. I'm one of those that believes the Internet is a bright spot In today's economy, it is not broken, and it does not need the FCC's help in order to be effective. Title II of the Communications Act is the regulatory nuclear option. It will stifle private sector investment in networks by creating regulatory uncertainty and lead to courtroom challenges. We know that Title II reclassification could result in as much as $11 billion in new fees and taxes. We welcome you here today. We look forward to hearing your viewpoints and to a lively discussion, and I yield back.
Thank the gentlelady, and now recognize my friend from California, the ranking member of the subcommittee, Ms. Eshoo, for an opening statement.
Thank you, Mr. Chairman, and welcome to all of the witnesses, most especially our former colleague who is a distinguished member of this committee, both as chairman of the subcommittee and ranking member of the subcommittee. Mr. Chairman, I had a wonderful statement that I was going to read, but I received a letter from Engine. It's dated February 18th of this year. It's addressed to the Federal Communications Commission, and I think that that what they had to say and the 102 entrepreneurs and startups that signed the letter is really an eloquent statement about where we are and where we need to go. And it reads, "Dear Commissioners, we are the small independent businesses and entrepreneurs that Commissioner Pai referenced in his February 6, 2015 press release about the FCC's impending net neutrality rulemaking. And we write to say unequivocally that his release does not represent our views on net neutrality. Quite the opposite. Entrepreneurs and startups throughout the country have consistently supported Chairman Wheeler's call for strong net neutrality rules enacted through Title II. For today's entrepreneurs and startups, failures to protect an open Internet represents an existential threat. Because net neutrality is such an important issue, the startup community has been engaged in the Commission's open Internet proceeding to an unprecedented degree. The clear, resounding message from our community has been that Title II with appropriate forbearance is the only path the FCC can take to protect the open Internet. Any claim that a net neutrality plan based in Title II would somehow burden, quote, small independent businesses and entrepreneurs with heavy-handed regulations that will push them out of the market, unquote, is simply not true. The threat of ISPs abusing their gatekeeper power to impose tolls and discriminate against competitive companies is the real threat to our future. Contrary to any unsupported claims otherwise, we believe that the outlined proposal that the Chairman circulated last week will encourage competition and innovation by preventing ISPs from using their gatekeeper power to distort the Internet market for their own private benefit. A vibrant Internet economy depends on an open playing field in which small, innovative entrepreneurs can compete with incumbents on the quality of their services, not on the size of their checkbook or their roster of lobbyists. In Verizon versus FCC, the D.C. court stated in no uncertain terms that without reclassifying broadband under Title II, the FCC cannot impose the bright line bans on ISP discrimination that startups need to compete. As such, any plan that does not include Title II reclassification cannot support strong net neutrality rules. We're pleased that Chairman Wheeler has recognized this simple reality. His plan is the best proposal we have seen to date for protecting the open Internet. And while there are important details yet to be finalized, the substance of the rules that the Chairman circulated last week are encouraging. Any attempt to undermine the Chairman's proposal through obfuscation and innuendo is not productive and certainly does not represent the opinion of the startups and entrepreneurs that have worked so hard to make the Internet great. And again, the letter is from Engine, and it is signed by 102 startups. And obviously, that's now part of the record. I also would like to place in the record, ask for unanimous consent to place in the record the editorial by Chad Dickerson, Etsy CEO, that testified before the committee, and I want to yield the remainder of my time, thank you, Mr. Chairman, to Congresswoman Matsui.
I thank the ranking member for yielding me time, and I welcome the witnesses here today. The future of this Internet has sparked unprecedented interest. We all know that. Let's not forget that over 4 million Americans took time out of their day to share their voices with the FCC on the future of the Internet. The American people overwhelmingly rejected the idea of so-called Internet fast lanes, and as a result, Chairman Wheeler rightly made a U-turn to ban paid prioritization agreements. An absolute ban on paid prioritization is a right move for the future of the Internet. Tomorrow's FCC vote will not be the end of the road. In some ways, the vote will be the beginning of the fight to preserve net neutrality and protect consumers and encourage innovation. That is why it will be critical for the FCC to maintain the flexibility for the Internet age. I look forward to the FCC's vote tomorrow, and I will continue to work with my colleagues on this moving forward. And I yield back the balance of my time.
Generally yields back. Chair now recognizes Chairman of the full committee, Mr. Upton of Michigan, for an opening statement.
Well, thank you, Mr. Chairman. In less than 24 hours, the FCC will begin proceedings to greenlight new net neutrality rules that rely on outdated utility-style regulations to govern the Internet. They're taking this path in part because of the limits on the FCC's statutory authority and in part because of political pressures to act. Unfortunately, whether intended or not, this approach brings with it a host of consequences that have the potential to disrupt the Internet that we have come to know and rely on. Title II means applying regs that were never meant for this technology or marketplace, and relying on unstable legal ground to refrain from applying others. It also means an inevitable return to the courts for net neutrality rules, which will lead to more years of uncertainty for consumers and providers. And until it's resolved, there may be no rules of the road for either consumers or industry. To avoid this result, Chairman Walden, Thune, and I offered draft legislation proposing net neutrality rules guided by the principles for an open Internet that we all share. Our committee has a rich history of taking on complex and difficult issues and finding common ground that both sides can support. Given what is at stake here, I had hoped that this would be another instance of such bipartisan cooperation. While I knew that not everyone would be interested in the legislative path, I am both surprised and deeply disappointed that we've not yet been able to engage in a negotiation and produce bipartisan product with our colleagues. But tomorrow's commission vote does not signal the end of this debate. Rather, it is just the beginning. And I've yet to believe that as members review the FCC's rules and hear today about the many problems that will result, there will be an opportunity for a thoughtful solution like the one we have offered. Bright line Internet rules of the roads, safeguards to encourage innovation and enforcement, mechanisms that allow the FCC to protect consumers without years of court battles. A legislative answer to the net neutrality question will finally put to rest years of litigation and uncertainty. Today's hearing will illustrate many of the harms that could come from the FCC's Title II approach to net neutrality. Let's work to avoid those landmines and get this done here in Congress, where policy decisions should belong. There's no question that Americans deserve the most robust and innovative Internet possible. This requires clear rules tailored to protect consumers and companies, rules like the ones we have put forward in our discussion draft, and the same rules the FCC chair, President Obama, and Democrats in Congress have sought for years. Once again, I would urge my colleague to work with us and help put net neutrality into law in a way that avoids the costly, harmful consequences that we'll hear about today. It's the right thing to do, so let's get it done. I yield the balance of my time to the Vice Chair of the Subcommittee, Mr. Latta.
Well, I appreciate the Chairman for yielding, and thanks very much for witnesses for being with us today. Look forward to your testimony. The FCC will vote tomorrow on a net neutrality proposal that reclasses broadband Internet access service under Title II of the Communications Act. I strongly disagree with this approach. Time and time again, we hear from businesses large and small that the reclassification will disrupt our flourishing Internet ecosystem by stifling innovation and slowing investment. Subjecting a thriving, dynamic industry to navigate the FCC's bureaucracy and red tape will adversely alter the Internet as we know it today. Furthermore, the FCC's proposal will inevitably introduce legal uncertainty due to its lack of statutory authority. The discussion draft brought forth by Chairman Upton and Walden is a strong indication to this issue. a strong solution to this issue. A legislative fix will provide regulatory certainty and enact the President's network management prohibitions without treating broadband as a common carrier. I look forward to the hearing today, and Mr. Chairman, I appreciate you yielding, and Chairman Walden, I yield back. Thank you.
Gentleman yields back the balance of the time. Chair now recognizes the ranking member of the full committee from New Jersey, Mr. Pallone.
Thank you, Mr. Chairman. As I said before, net neutrality is critical because access to the Internet is critical. We go online to apply for jobs, to help our kids with their homework, and to grow our businesses. These are just a few of the reasons why 4 million Americans reached out to the FCC demanding strong network neutrality protections. Due to this overwhelming civic engagement, we're on the eve of an historic event at the FCC. Tomorrow, the Commission is set to put into place what may be the strongest Internet protections consumers have ever had. And for all of you who called in, who wrote in, who came in to support net neutrality, you will see that the FCC and the rest of Washington knows how to listen, even if it doesn't always appear that way. So I welcome the Republicans' change of heart and their effort to legislate. I remain open to looking for ways to enshrine the FCC's network neutrality protections into law, but our effort can only work if it's truly bipartisan, which is why I'm baffled about why we're holding this hearing today, Mr. Chairman. Just a few weeks ago, this subcommittee met on these same issues. We all heard a number of major concerns with the Republicans' discussion draft. We all heard that these are complicated issues that take more than a few weeks to sort through. This subcommittee and our full committee has too much other important work to do to have the same hearings over and over again. For instance, the FCC just completed the most successful auction in history for our nation's airwaves. We could be spending this time building on that auction and establishing a spectrum pipeline for the future. We are nearly 2 months into the new Congress with very little to show for it. I think this subcommittee has enough talent to do more than just obsess over one topic at a time. Our constituents expect more of us. Now, once we've all had time to review and evaluate the FCC's rules and their effects, we can hopefully look for ways to find and reach consensus on a bipartisan legislative draft. But now is not that time. Now is the time for the FCC to do its work. I know that Chairman Wheeler will do everything in his power to release the FCC order as soon as he can after the vote. To deliver on that promise, however, the Chairman needs the cooperation of his fellow commissioners. So I ask all of the commissioners at the FCC, even those who may disagree with the final decision, to work with Chairman Wheeler to make this order public as soon as possible. And I now yield the remainder of my time to the gentlewoman from New York, Ms. Clark.
I thank our ranking member, Mr. Pallone, as well as our ranking member, Ms. Eshoo, for yielding me time today. I'd also like to thank our witnesses for lending their expertise to today's hearing. Mr. Chairman, protecting the free and open Internet is truly and essentially an issue of access to economic opportunity. More than 80% of Fortune 500 companies require online job applications. Our constituents simply cannot compete without access to all that the Internet has to offer. In my district and across our country, people are increasingly moving to their smartphones and tablets as their primary access point to the Internet. That is especially true for the most economically vulnerable Americans. 77% of our low-income families rely on their mobile phones to get online. So I support making sure that all Americans have open access to the Internet. People should be able to find the content and applications they want no matter who they are or where they live. They should not be constrained by Internet gatekeepers. And the time has finally come to establish certainty in this regard. Therefore, I urge the Federal Communications Commission to finish its work. 4 million Americans have called in on the FCC to adopt strong network neutrality protections. That eye-popping number demonstrates how important this is. The country has waited long enough. I thank you, and I yield back.
Gentlelady yields back the balance of the time. And now we will move forward to hear from our witnesses. We again thank you all for being here today to share your expertise on this issue as we move forward. I want to start with former chairman of this subcommittee, Mr. Boucher of Virginia, who is with the Internet Innovation Alliance now as the honorary chairman. Mr. Boucher, we're delighted to have you back, as we've all said, and we look forward to your commentary this morning.
Well, thank you very much, Chairman Walden and Ranking Member Eshoo and other members of the subcommittee. It's a privilege to accept the committee's invitation to return to this very familiar surrounding and to share with you this morning my views on the best way to assure protection for network neutrality. As the chairman said in the introduction, I'm the honorary chairman of the Internet Innovation Alliance. It's a membership organization. We have 175 members, including some technology companies. I'm also a partner at Sidley Austin. We also there have clients who are telecommunications companies. But here today, I'm expressing my own views, not the views of our law firm's clients or of the Internet Innovation Alliance. From the very time that the debate began about a decade ago on the network neutrality issue, I have been a strong proponent of network neutrality and of embedding essential network neutrality guarantees into our federal law. In those days, I joined with now Senator Markey and Congresswoman Eshoo and others on this committee in a legislative effort that at that time was not successful to assure network neutrality guarantees. I remain as strong a supporter today of network neutrality as I was then. I believed then, as I believe today, that assuring an open Internet is essential to maintaining the web as a vibrant medium for free expression, for commerce, for education, for healthcare delivery. It's clearly the most capable and versatile communications medium that has been derived to date. To keep it that way, I'm here today to urge that the committee develop a narrow bipartisan bill that gives statutory permanence and an assured legal foundation to network neutrality. I'm concerned that if Congress does not act, all protection for network neutrality is at risk of being lost. FCC Chairman Wheeler has said that his reclassification order that will be approved tomorrow rests on a stronger legal foundation than the FCC's 2010 Open Internet Order, which ultimately was overturned in court. And that may be true, but it certainly is going to be subject to legal challenge. And we can't know today what the outcome of that litigation is going to be. We can predict that the court decision will be years into the future in coming, and that will be at a time that is well into the next presidential administration. We can just look at the timeline for the Verizon decision that declared the Open Internet Order to be invalid. That didn't come until more than 3 years after the suit is filed. 3 years from now, we're into the next administration. If the Republicans win the presidency in 2016, the next FCC will have a Republican majority, 3-2, the mirror image of what it is today. And it would be very unlikely to appeal an adverse court decision or to institute a new proceeding that would establish network neutrality guarantees. In fact, it's very likely that a Republican FCC would move very quickly to reverse tomorrow's classification decision, even if that decision survives court determination. Tomorrow's reclassification order and the network neutrality principles it embodies truly rests on a tenuous foundation. Without statutory protection, the net neutrality guarantees can be swept away in the next presidential election. And judged from the polling we're seeing today, that's going to be a very close race. Therefore, my sole purpose in appearing today is to say that legislation is the superior solution. That is true for those of us who strongly support network neutrality guarantees. It's virtually impenetrable to judicial challenge and would resolve the debate with statutory permanence that is simply not available through the regulatory and administrative process. I know the Democratic members of this committee have raised concerns about the draft that has been circulated by the Republicans, but I would make a couple of points in closing. First of all, as Chairman Walden and Chairman Upton both have indicated, the Republicans have made a major move toward the historic Democratic position in offering to place strong network neutrality guarantees into federal law. In essence, they are offering to Democrats the very network neutrality principles that for a decade Democrats have sought to achieve. By the same token, Democrats have concerns, and I think it's important for the Republicans to acknowledge those concerns and address them in a bipartisan negotiation. Surely those concerns are subject to resolution. Candidly, I have some concerns about the draft legislation, and if I were on the Democratic side of the dais today, I would be expressing some concerns as well. In the end, what really matters is two key principles. First, establishing strong network neutrality guarantees, perhaps using the FCC's 2010 Open Internet Order as a model. And secondly, providing a continuation of the light touch information service Title I treatment of the Internet that has welcomed investment and made it a dynamic platform that has become the envy of the world. Everything else should be open to discussion, negotiation, and resolution. At the moment, both sides have leverage. Both sides have the opportunity to obtain their key priorities, and I very much hope that a conversation will ensue and that you will adopt legislation that does a service for the country and keeps the Internet open and maintains the light touch regulatory treatment that it enjoys today. Thank you very much for having me here, and I'll be pleased to take your questions.
Mr. Boucher, thank you very much for your testimony and your comments. We'll now go to the President and CEO of Public Knowledge, Gene Kimmelman, not a stranger to our committee. We welcome your comments as well, sir.
Thank you so much, Mr. Chairman, Ranking Member Eshoo, members of the subcommittee. On behalf of Public Knowledge, which is a nonprofit that promotes creativity, freedom of expression on open communications platforms, I'm pleased to appear before you this morning, and I am most honored to join with millions of consumers, citizens, civil rights activists, startup companies, small businesses, to praise the direction that Chairman Wheeler at the FCC is going in his proposed rules for an open Internet, because it is those rules that will do more for our society to promote freedom of expression and opportunity on what has become the most important platform for economic opportunity, social mobility, as Mr. Boucher said, education, health care. That is the Internet. These rules are critical. The proposed rules, as we understand them, actually follow a long tradition of the FCC flexibly applying the mandate that this Congress has directed it to follow in preventing discriminatory practices that are unjust and unreasonable on communications platforms. They are perfectly aligned with what this Congress has asked in the past and update in conjunction with all the innovation and technology that we've seen exploding in this space, the fundamental principles that are necessary to promote freedom of expression. It is the Title II principles that have been undergirding through all of our communications infrastructure, the explosion in investment, the tremendous innovation in telecommunications that we've experienced in the last few decades, and the enormous growth in the Internet economy. It is those same principles the FCC is applying, as we understand it, in tomorrow's ruling. We think this just continues through light touch regulation, as again Mr. Boucher referred to, the approach that this Congress has always been asking the FCC to be sensitive to, with clarity in its policing tools, that are necessary to guide an open internet and prevent unreasonable discrimination on that platform. We believe that's all they're doing. Now, I understand from the comments made already this morning and that more that we'll hear that there are questions about regulation. There are questions about how to apply them. There are questions about how far they go. It's not unreasonable. It's not the first time. This is my third decade of going through debates about common carriage and discrimination, going back to the breakup of AT&T, through the computer inquiry, through the 96 Act, and now into the Internet era. These are the very same important principles to discuss. But here is one thing I'd like to highlight. I don't know Chairman Wheeler that well. I've come to know him better in the last few years, given where he sits and what he has said. And here's what I have seen. This is a chairman of the FCC who is very sensitive to the need for investment in infrastructure and expansion of broadband opportunities for Americans. This is a chairman who, my perception is, wants to regulate as little as possible to accomplish the goals that Congress has directed him to accomplish. And I therefore feel very confident that he is attuned to all the concerns that you're raising. He has listened to the public's input, and that these proposed rules, as we know them, are likely to be consistent with that. So while I fully understand the interest in legislating, I would urge you today to sit back and see what is put forward tomorrow. See what will work and what you think won't work. And then consider what Congress rightfully needs to do to step in and address those concerns. But I'll also suggest, please consider, if you are legislating, addressing all the other concerns that have been legitimately raised about potential shortcomings in the Communications Act. In that endeavor, we look forward to working with you as you move forward. Thank you so much, Mr. Chairman.
Mr. Kimmelman, thank you for your testimony as always. I would just point out we're not doing a markup today. On legislation, we actually have said we're not going to do a markup until we see what the FCC does, but we wanted to hear from people like you about what you know about the Act at this point, or the order at this point. We're going to go now to Mr. Atkinson, the founder and president of Information Technology Innovation Foundation. Mr. Atkinson, we're delighted to have you here this morning to get your perspective. Please go ahead.
Thank you, Chairman Walden and Ranking Member Eshoo and members of the subcommittee. ITIF is a think tank that focuses on advancing innovation and smart innovation policy. Let me start by arguing that I think it's time we should consign the term net neutrality to the dustbin of history. It's a misleading term, it's a biased term that has driven the debate to the false conclusion that there's a one-size-fits-all Internet, and that absent Title II, Internet Armageddon is one decision away. Neither of these claims are true. Instead, what we need to be talking about is the need for effective network policy for the 21st century. 10 years from now, our goal should be to have a better, smarter Internet than we have today. And to be sure, it should be a network that effectively polices abuses. We have been and have continued to be long supporters of the view that Internet providers should not be able to capriciously block or degrade or create pay-to-play, forced pay-to-play. That has been our position for 8 years now in the debate. And when we see other nations that are doing things like shifting to a carrier pay model or allowing blocking competing applications of, for example, a VoIP, we strongly oppose those. And any rule should do that. But we also need a network that supports a rich diversity of applications with the optimal levels of performance. This is not the telephone era where you have one application riding on one wire. What you have are multiple different applications with multiple different needs, all riding on one wire. So the idea that we should have a rigid regulatory scheme that requires all traffic to be delivered the same way is a little bit like saying that we should force bicycles and mopeds to drive on the interstate with sports cars or tractor trailers. Or it's a little bit like the Postal Regulatory Commission telling the U.S. Postal Service that they can no longer have priority or express mail. You can only deliver mail at one speed. And that's really what we're talking about here. So in other words, there are two threats to the Internet today, or potential threats. One is unreasonable discrimination, which we've seen, frankly, very, very little of. And the other is the risk of a dumb, static network that doesn't evolve as the Internet economy evolves. Title II, in our view, is a bad idea because it embodies the second of those two visions instead of the first. But Title II is a bad idea, not just because of its rigidity, but because of the uncertainty it puts industry, both network providers and edge providers, under. As the Honorable Rick Boucher said, the notion that Title II is going to put regulations on a sure footing is simply wrong. To think that Title II will provide certainty for anyone but the FCC is a pipe dream. As Congressman Boucher referred to, there will be significant legal challenges, significant legal uncertainty, and certainly political uncertainty. Whoever the next president could go in either direction, could go towards banning, going back to Title I, or could go and say we're going to reverse any kind of forbearance actions that this current FCC chairman is committed to. So we just simply have no idea what's going to happen. Significantly, if Title II goes forward, there's also going to be uncertainty over its implementation. Chairman Wheeler has tried to mollify critics, saying that he will forbear, and forbear from this, and from that, and from this. But the fact that he has to give assurances is proof that Title II is a kludge of a solution. It's not a solution when you have to take a whole components of it and move it off the table. It's a little bit trying to fit the square peg of a smart network policy into the round hole of Title II telephone regulation. The other problem or challenge with the chairman's actions is that many groups are going to file petitions in terms of forbearance. We already have some groups already, and I will refer to my colleague Gene Kimmelman's organization. Public Knowledge has asserted just last week that they intend to push to use Title II to require broadband providers, including new entrants into the marketplace with innovative business models deploying fiber, to serve all areas of a community at once. This may or may not be a valid view. In our view, it's not, but it has nothing to do with net neutrality. We've seen Free Press state, quote, "With Title II, we have the legal authority to win the battles that are coming around the bend." So this is not really an argument about net neutrality. This is an argument about broad-based regulation of network providers. So as going forward, the only way, in our view, to achieve certainty for edge providers and network providers is congressional legislation. And to achieve that certainty, we would argue that balance needs to be the watchword as you go forward. And we need to have balance between the edge and the core. We need balance between requiring a one-size-fits-all dumb pipe and allowing capricious discrimination. Neither of those solutions is the right way. And frankly, we need balance between the overgovernance of Title II and the undergovernance of doing nothing. We believe that it's possible and desirable to get that kind of solution that serves everybody's interest in the debate. There's a real moment of opportunity. What we've heard today is a broad consensus on the principles, and we believe that Congress should work together to draft the kind of framework we need for network policy for the 21st century. Thank you for the opportunity to appear before you.
Mr. Atkinson, we appreciate your comments, and thank you for being here today. We'll now go to our final witness this morning from the Internet industry. He's an analyst and an author, Larry Downs. Mr. Downs, we're delighted to have you here as well. Please go ahead.
Thank you, Mr. Chairman, Ranking Member Eshoo, and members of the subcommittee. I appreciate the opportunity to testify before you today. I am based in Silicon Valley, have been for over 20 years, and have been actively engaged in what really is the remarkable development of the broadband Internet ecosystem in several capacities, including as an entrepreneur and advisor to startups and investors. Since March 2014, I've also served as a project director at the Georgetown Center for Business and Public Policy, studying the increasingly uncomfortable tension between the accelerating pace of disruptive innovation and the necessarily deliberative processes of government. My written testimony focuses on four major concerns with the FCC's pending proceedings, which I'd like to summarize now. Number one, Chairman Wheeler's flip-flop from pursuing open Internet rules to what now appears a full-force effort to transform broadband into a public utility threatens to end nearly 20 years of bipartisan policy favoring light-touch regulation of the Internet, perhaps the most successful approach to regulating an emerging technology in history. Under the visionary approach of Congress, the Clinton administration, and FCC chairman of both parties at the time and since, the 1996 Act wisely left Internet governance to the engineering-driven multi-stakeholder process, a process that continues to rapidly evolve and improve the Internet's architecture, protocols, and network management technologies. Number two, The May 2014 NPRM, which promised to follow the, quote, roadmap laid out by the Verizon Court to reenact the Open Internet rules under the authority of Section 706, now appears to have been jettisoned in favor of an all-inclusive plan to regulate every node of the Internet infrastructure, including peering, transit, and other essential but non-neutral network management principles the 2010 report and order wisely and explicitly excluded. Though we have yet to see the final report and order, it is reported to be over 300 pages long. Its length will challenge even its strongest proponents to say with a straight face that it is in any way a simple or light touch resolution to a decade of debate over the appropriate and legally permitted role of the FCC in policing the Internet. And as we know from its 2010 counterpart, most of its most contentious and legally challenged aspects will be intentionally buried deep in the text and in hundreds of footnotes. The jurisdictional gymnastics were bad enough in 2010. Now, given the acknowledged misfit, both from a legal and policy standpoint of Title II, written decades ago to closely regulate the former public switch telephone network, monopoly, the process is already confounded by the need to first transform the Internet into a public utility and then immediately begin the process of unraveling that decision. Having selected the blunt instrument of Title II, the FCC, in its discretion, must continually decide on its least appropriate provisions and attempt to undo them through clumsy and legally uncertain forbearance proceedings. At the very least, extensive forbearance invites the worst kind of rent-seeking behavior by self-interested parties throughout the Internet ecosystem. Number 3, recent developments in this long-running debate over who and how to regulate the Internet have now made clear that for many advocates, open Internet rules were always the populist tail wagging the shaggy Title II dog. Though the rhetoric of net neutrality remains the substance of the FCC's pending rulemaking, instead advances a long-running campaign to abandon the light touch model and replace it with a public utility regime, the goal all along for many supposed open Internet advocates. Though the FCC may today attempt, or not, to forbear from the most damaging provisions of Title II, the campaign is already preparing to drive the Title II wedge as far as possible, which for the most vocal advocates have always included mandatory unbundling, required build-outs, pre- or post-hoc rate regulation, universal service fees and other taxes, and shared jurisdiction with state public utility commissions. Perhaps the light touch model was wrong all along. Perhaps the transformation of the Internet into a public utility would do a better job of encouraging investment, adoption, and innovation. I don't think so, but if that is what we are debating, we should at least acknowledge it and move the debate to Congress, where it obviously belongs. Number 4, abandoning the Verizon Court's Section 706 roadmap in favor of a public utility regime, as the Chairman has not hesitated to acknowledge, introduces considerable legal uncertainty that at best will mean another 2 years or more without resolution to the open Internet debate. It is not simply my personal belief that Congress never intended for broadband Internet to be regulated as a public utility like the old telephone network. That, of course, has long been the interpretation of the 96th Act of the FCC itself, an interpretation ratified in 2005 by the United States Supreme Court in the Brand X case. Overcoming a decade of FCC policy and Supreme Court precedent will require considerable innovation and outright creativity by government lawyers that will certainly take years to resolve one way or the other. There is a better way, one that removes all legal uncertainty in an instant and avoids many of the intended and unintended consequences of the public utility gambit. The legislation introduced last month in both the House and the Senate would quickly and cleanly resolve the FCC's persistent jurisdictional problems and enact precisely the rules called for in even the most aggressive articulation of open Internet principles. Though I continue to believe the engineering-driven multi-stakeholder governance of the Internet is the optimal solution, one that has worked with remarkable efficiency since its inception, I have from the beginning supported the proposed legislation, if only as a way to end the largely academic debate about the need for what the FCC itself calls, quote, prophylactic rules. I thank you again for the invitation and look forward to your questions.
Mr. Downs, thank you, and thanks to all of our witnesses for testifying today. We appreciate your comments, your suggestions, and your concerns. I'd like to ask unanimous consent to submit into the record a opinion piece written by Robert McDowell, former FCC Commissioner, and Gordon Goldstein. It was in the Wall Street Journal entitled, "Dictators Love the FCC's Plan to Regulate the Internet. The Obama administration's efforts to treat the web like a utility has fans from Saudi Arabia to the Putin's Kremlin." Without objection.
Come on.
Well, I don't generally comment on the submissions you have. So, Mr. Downs, the U.S. recently returned from a treaty conference in South Korea where our delegation fought to keep the Internet from coming under the purview of the UN's International Telecommunications Union. The ITU has an extensive set of regulations that apply to telecommunications, including economic regulations on interconnection. With the FCC redefining broadband Internet as a public utility telecommunications service within the ITU constitutional remit, and with the FCC stating that its regulatory powers would include Internet interconnection agreements, have the implications for international termination agreements been considered by the Commission? And what effect do you think this will have?
Thank you, Mr. Chairman. So, of course, again, we have to qualify that we have not seen the full report. We don't know exactly how they're going to do this. But certainly, if we are talking about a telecommunications service, that is within the purview of the ITU and the treaties that the U.S. is subject to in conjunction with its membership in the ITU. Whether or not this is going to stand up legally, I think there's no question that those forces within the ITU that are eager to introduce things like sending network pays models that we've had on telephone service and introduce that for Internet service as a way of subsidizing their own local broadband connections. They will certainly make the argument, whether they're successful or not, that our move undermines our longstanding commitment to keeping the Internet away from those kinds of telecommunications and settlement regimes. And really, it certainly undermines our moral high ground in saying so, whether or not they get away with it or not.
Under GATS, countries that declare services to be basic services like telephony could limit U.S. investment opportunities abroad. Up until now, the USTR has argued that Internet broadband is a value-added service. And importantly, in many country trade commitments, there are more liberal market access opportunities for value-added services as compared to basic services. For example, China has more restrictive rules for who can obtain a basic service license. And China has defined services connected to the Internet to be basic services, a definition that the U.S. Trade Representative has challenged in the past. Taking this as an example, could the FCC reclassification to a telecommunications utility, as they're doing allegedly under their rule, change USTR negotiating positions abroad and result in closing market access and competition opportunities for U.S. companies?
So I don't feel comfortable sort of answering the question in terms of what it would force the USTR to do, but certainly, as I say, from a rhetorical standpoint, it makes our negotiating position, our leverage, much more subject to those kinds of arguments coming from the countries we have been urging so strongly over the years to try to keep Internet as a light-touch regulatory model the way we have historically done.
All right. Mr. Atkinson, you raised some issues involving Mr. Kimmelman's organization. I'd like to hear you pursue that a bit and then get Mr. Kimmelman's reaction as well. What else do you see out there in terms of what the FCC is proposing in their open Internet order?
Well, again, we haven't seen it, but I would agree with Mr. Downs that the net neutrality argument for some groups, not all groups, and I don't really believe this is true for most of the industry advocates, for example, in Silicon Valley. But the net neutrality argument, in my view, has been a stalking horse for going back to a network that is highly regulated and ultimately going back to a network that is publicly owned. I think that is the end goal for many of these organizations. They want cities or governments to be running these networks, and they equate them to roads, which most roads are publicly operated and publicly funded, not all. And so I think what we'll see, and I didn't mean to just point out public knowledge alone, because there are other groups that do that, but I noticed it last week when I was on their website, and it was pretty stark. It was essentially saying that they would use the Title II power to require broadband providers to roll out broadband in a certain way. Now, if you do that, I think what the end result will be much less competition, because it's harder for new entrants to come in. New entrants can come into a market and put a little bit of broadband here. They may not have the capital, they may not have the markets right away, but if you require them to serve an entire area from the day one, you will simply get fewer competitors coming into the wireline marketplace, and I think that's going to end up hurting. So I think we'll see more and more of that, as my prediction is if Title II decision is made tomorrow, you'll see a sort of a period of sort of quiet for maybe 3 or 4 months, and then you'll start seeing this next sort of way. Well, we've done that for net neutrality, but what about this? What about prices? What about discrimination? So I think it's just really the first step that we're going to be seeing here.
Appreciate that. Mr. Kimmelman?
Thank you. I think Mr. Atkins has just fundamentally misunderstood what was a Q&A session that was reported on our website. It was a response to a question about, is there a concern for redlining as broadband is built out, denying service to low-income marginalized communities. And our staff indicated that there was a concern. We didn't call for regulating everyone.
All right.
And I think, as Mr. Atkinson knows, we have supported differing treatment of dominant and non-dominant carriers for years and years and years. Everyone knows that as competition grows, you need to let startups get into a market and challenge the dominant players. So I think that's just a misunderstanding.
Mr. Atkinson, anything else? 5 seconds.
Well, I'd be happy to submit to the committee the actual statement that a public knowledge employee, researcher, puts on there, and it's very clear that they intend to use Title II for this purpose.
All right. My time's expired. Recognize my friend from California, Ms. Eshu.
Thank you, Mr. Chairman, and thank you to all the witnesses. First, on the issue of equating the open Internet rules with repressive government attempts at online censorship, I really think is misinformed and irresponsible. Several of the governments seeking to expand the UN and ITU role in Internet governance are actively engaged in blocking their citizens' access to information online. And that's very important to have down in the record. This is the opposite of U.S. policy. This is not U.S. policy. It's a stark opposite of it. We adopted the open Internet rules to protect consumers' access to the content of their choosing. That's one of the basic tenets of an open Internet. So I think it's important to get that down for the record. Let me just, I have several questions. I doubt that I'm going to be able to ask all of them. I ask that you keep your answers brief. Mr. Downs, you're really lathered up about this. Last week, T-Mobile, this is on the issue of investment and this whole notion, wild accusations that the market is going to be chilled, there isn't going to be any investment. Last week, T-Mobile became the second major wireless carrier to downplay the implications of Title II on their ability to continue investing. So how do you reconcile T-Mobile statements and similar comments by Sprint with your belief that the FCC action will threaten the long-term health and continued investment in broadband?
Okay, thank you, Ms. Hatcher. I can't obviously comment on what T-Mobile and Sprint are thinking and their reasoning, but what I can say is, you know, under this light touch bipartisan policy we've had the last 20 years, we've had over $1 trillion of investment in broadband. Both.
No, but I'm asking you, the charge is, and it's been made by those that oppose essentially my position and those of, you know, like-minded individuals and organizations, it's a very heavy charge that's been made. So how can you reconcile it? Do you have proof? Is there a lack of investment? Is there already a chill? Do you have information from the New York Stock Exchange or others? I think it's one thing to say we're concerned about something. It's another thing to make a charge that A is definitely going to happen and it's going to produce B. So let me move on. To Rob Atkinson, thank you, good friend. I'm an honorary co-chair of ITIF. I'm proud to be. In the absence of robust broadband competition, I think there's an even greater need for strong, enforceable open Internet rules. Now, your testimony doesn't raise this issue, but the facts, I think, point to a rather dismal picture. At speeds of 25 megabits per second, nearly half of Americans have just one choice. At slower broadband speeds of 10 megabits per second, 30% of all Americans still have only one choice. So what would you propose be done to enhance broadband competition? And just be as brief as possible. If you have like maybe 3 bullet points.
Well, first of all, as we've written on that, no country in the world has a majority of its connections over 25 megabits. Even North Korea. North Korea certainly doesn't. Even South Korea, which is.
Yeah, but we're talking about the United States.
Right. But my point is, Congresswoman, my point on that is simply 25 megabits I think is a standard that's just too high. No country meets it. So we do have robust competition, more around the 10 to 15 megabit range where we have a lot of providers competing. But I would agree with you. I don't think competition, you can have more competition or less competition. And I would fully agree. It doesn't mean that we shouldn't have rules, because even with competition you can have abuse. So I agree with you, we need rules.
Okay. I'm going to ask you to stop so I can get to our friend Rick Boucher. And it's wonderful to see you, and thank you for being here today. 8 years ago, you introduced the Community Broadband Act of 2007. Yourself and then Representative Upton, as a way to overturn state bans on municipality-built broadband networks to spur deployment. Would you still stand with that today?
My views have not changed, Congresswoman.
Good.
I believed then and believe today that where the incumbent providers are not offering an adequate service, and in many places their service is either quite slow or in some very rural communities and reaches of the communities non-existent. If the community wants to step up and provide a broadband service that enhances economic development, then it ought to be free to do so. I would just note that in one community in my former congressional district, the city of Bristol, the public utility there that is city-owned overbuilt the incumbent provider and offers a gigabit-level network that has been tied directly to the creation of more than 1,000 jobs in that community. So, yes, I think it makes a lot of sense. I indicated that my testimony here today is entirely my own views, and you've asked for my view, and I can assure you that my view has not changed.
Well, that's wonderful, and I hope that the chairman, the FCC chairman's proposal includes what you began many years ago. Thank you. I think my time has more than expired.
Gentlelady yields back. Chair now recognizes gentlelady from Tennessee, the Vice Chair of the full committee, Ms. Blackburn, for 5 minutes.
Thank you, Mr. Chairman, and thank you to each of you for your time to be here. Our constituents are really concerned about this issue. As I said in my opening remarks, they don't think the Internet is broken, and they don't understand why the FCC would be trying to step in. So we appreciate hearing from you. Another thing that I hear, and I want to take my questions in this direction, is the issue of new fees and taxes. I know Progressive Policy Institute had a study, and they said maybe $11 billion in new fees and taxes, and then January 16th, the Washington Post ran a story attacking that figure, but then they noted that through interviews with tax and regulation experts that Title II reclassification would likely, and I'm quoting, cost some consumers something. And we know that Chairman Wheeler is, as Mr. Atkinson, you pointed out, there has been discussion about forbearance from applying universal service fees on broadband and other components. And so we do have concern about this in the reclassification, that it will lead to some amount of increased fees and taxes. And February 2nd, the New York Times ran a piece titled, "In Net Neutrality Push, the FCC is expected to propose regulating Internet service as a utility." And in that piece, David Farber, Professor Farber from Carnegie Mellon, and I think all of you probably are familiar with him. He helped design parts of the backbone of the Internet. And as we say in Tennessee, it was not done by Al Gore. It was done by others. But the article states, Professor Farber commented, and I'm quoting, "Regulating the Internet like a telecom service potentially opens up a Pandora's box," end of quote. And he advised that information services are typically free of taxes, while telecommunication services are not, especially at the state level. So what I want to ask you all, looking at these components from Progressive Policy Institute, the review of that by the Post, the comments as in the New York Times by Professor Farber, does anyone on the panel dispute the conclusions of Dr. Farber the Progressive Policy Institute, and the Washington Post. Mr. Kimmelman, go ahead.
Ms. Blackburn, I certainly dispute the implications of what's being said. It's being said as if there will be new taxes and fees. My understanding is the chairman's proposal will have no new federal taxes and fees. He's forbearing from a portion of Section 254, as I understand it from his own description of what he will propose tomorrow. So there will be no federal taxes and fees. As to state and local government, which I believe is what Dave Farber was also referring to, it is today the case that every state can decide on its own what it wants to tax, what it wants to impose fees on, subject to limitations that this Congress is and has imposed on the Internet tax moratorium legislation, which you can adjust as need be to make sure that states and local governments do not go beyond what you think is reasonable.
Okay, so Mr. Kimmelman, you are disagreeing with the conclusions of Dr. Farber. You disagree with him as one of the architects of the Internet.
I don't believe he's the architect of tax systems. I believe that is your job here and what state governments do. And he presented a point of view of what he thinks might happen somewhere. And
okay, I'm going to interrupt you again so we can continue on this. So let me ask you this. How much do you anticipate it's going to cost consumers in private industry, especially if USF funds are eventually applied to Internet access? And most people agree, even free press, that reclassification would lead to some net increase in taxes and fees of about $4 billion. So what do you really think?
I'm hopeful, Ms. Blackburn, that the FCC will review its universal service rules, will do something about the approximately 10% way too inflated fee that all of us are paying on our telephone bills, and figure out a better system where we actually all pay less. I believe that is totally plausible.
Mr. Kimmelman, let me ask you this in my few seconds that remain. Were you or your organization, Public Knowledge, privy to any of the closed-door sessions at the White House where there was a discussion on what the net neutrality order would look like coming from the FCC?
No, Ms. Blackburn, we're not privy to any
Have you seen draft language?
No, I have not.
Yield back.
Gently yields back, and I now recognize Mr. Pallone.
Thank you, Mr. Chairman. As I said it just a few weeks ago at the subcommittee's other open Internet hearing, one of the important aspects of net neutrality is ensuring that the FCC stand ready to protect consumer privacy, whether with regard to consumers needing telephone access or consumers needing broadband Internet access. Yet yesterday, Administrator Strickling confirmed to me that the White House intends to release as early as this week its Consumer Privacy Bill of Rights proposal, which could effectively strip the FCC of its ability to regulate consumer privacy. The administration has not shared the proposal with members of this committee, but has shown it to industry. As confirmed yesterday under the current draft, which I am hopeful can be modified before release, telephone, Internet, or cable companies can get out of FCC privacy oversight by creating a self-regulatory privacy code of conduct through a multi-stakeholder process. Specifically, these companies would no longer be covered by Section 222, the privacy section of Title II, or other similar provisions. So, Mr. Kimmelman, I wanted to ask you, there are several concerns with the current draft privacy bill from the White House, from basing it on a tried and failed multi-stakeholder process to potentially weakening FTC's current authorities. However, can you please comment on the concept of allowing telephone, Internet, and other providers being relieved of their obligations under Section 222?
Thank you, Mr. Pallone, and I appreciate your strong concerns about this. I certainly hope what you have heard is not accurate. I think this could be an enormous problem for consumers who have relied on the ability to protect their own personal privacy on telephone calls and their own viewing habits over cable television. That has been what Section 222 of the Communications Act has been applied to most generally. I certainly hope the administration is not considering rolling that back.
Can I ask you, I don't know if you wanted to respond to anything else that members have brought up so far. If you haven't had the opportunity, you wanted to comment further.
I would like to say something about the ITU, having spent a bit of time at the WICET conference where Rob McDowell was as well. I think there's a little bit of a misunderstanding or a sleight of hand here of raising telecom utility as a definition, which I do not believe is what, based on what I have seen of the statements of the chairman of the FCC, he is proposing to do with his open internet order and drawing things into some broader regulatory framework at the ITU. I just don't believe that's on the table. On the contrary, I believe that from the description that's been provided of the proposed plan, it is the actual effectuation of the U.S. government's position against Russia and China and Iran and other repressive regimes that we not only ask other governments to prevent censorship and interference with their citizens' communications, but we ourselves practice that and do not censor citizens' communications on the open internet and do not allow corporate gatekeepers to do the same. So I view it as quite consistent with our past policies.
Well, thank you. Mr. Chairman, I just wanted to say, I know, and Ms. Eshoo and I were talking about this earlier. The Republicans keep talking about court challenges, and the fact of the matter is that anything can be tied up in a court challenge. And there was a time when the Republicans tried to avoid litigation. I specifically remember, they have and continue to talk about tort reform in the healthcare sector. But now it looks like the GOP wants to sue on everything. They sue on the ACA, they sue on immigration reform. I'm just, commenting on the fact that I really don't quite understand why, we as a subcommittee or as a committee have to be constantly worried about who's going to sue who, because we never know who's going to sue, no matter what the action is by the FCC or any other agency. So just a comment on the fact that I really don't think that we should be deciding what to do here based on, who we think is going to sue who. And certainly I see that, if anything, it's the Republicans that appear to be more litigious these days than our side of the aisle. I yield back.
Gentleman yields back the balance of his time. Chair now recognizes the former chairman of the committee, Mr. Barton, for 5 minutes.
Thank you, Mr. Chairman. And we are delighted to have the Honorable Boucher here. It is a level of the respect and the amount of intimidation factor that you've not yet been asked a question. We are afraid of you, Mr. Boucher. But I remember well the debates you and I have had, some on the same side, some on opposite sides, and we're delighted that you're here again. We love Robert Griffin. He's a great member of this committee, but we miss you, and we wish you well.
Thank you very much, Mr. Barton.
I do want to, we've talked about this issue of net neutrality, and Mr. Atkinson quite rightfully pointed out that that's a misnomer. Net neutrality, as espoused by the most aggressive proponents, there's nothing neutral about it. It's net regulation. What the FCC is probably going to vote on tomorrow is net nonsense. It's not going to work. It is going to be tested in court. It's going to fail in court. The chairman and the subcommittee and this full committee have put out a draft that would give some certainty, but would maintain the premise of true neutrality. Now, Mr. Boucher, you're a smart guy. You're a lot smarter than me, but you understand. And I want to commend you for you were the only one that really made any political comments. You put it on the table. You had great candor, and I appreciate that. But 1934, when we passed whatever we call that act, the Communications Act, there was one phone company, basically. Now, there were some small rural telephone companies, but you wanted a phone company in your particular area, you went to one company. Today in Ennis, Texas, if I don't like my internet provider, which is Charter Cable, AT&T will come in and do it for me. Verizon will come in and do it for me. There are any number of providers that all I have to do is pick up a solicitation letter in my mailbox, or next time the phone answers, say yes to somebody who wants to provide me different internet services. There's all kinds of competition. Title II was passed when you had one provider. You agree with that?
Mr. Barton, I don't disagree with anything that you've just said.
Including you're smarter than everybody else.
The tone that I would express that sentiment in is the following, that there is a better way Title II is kind of a blunt instrument. It's a relic from another era that doesn't fit very well in today's highly competitive communications market, where you've got the world's most capable platform for delivering information of all kinds, and multiple parties offering access to that platform depending on whose service you want. Title II was never conceived for an environment like that. There is a better way, and the better way, I'll come back to my original remarks, is for this committee...
I'm going to let you filibuster too long.
Well, I'm only going to take about 10 seconds here, but you come together on terms that are for today's modern era, that offer network neutrality assurances and maintain broadband as a lightly regulated Title I information service. That honestly is what is called for in today's
in the
environment.
chairman's draft, as he's put out, you would generally support?
I think it moves in the right direction, and I think it's important to note how far the Republicans have now moved toward the historic Democratic position.
See, and that bothers me.
Well, I know you, and I'm not surprised. But I hope you'll see the light this time. And let me just say that I think it is a major development that now everyone is talking about the best way to preserve network neutrality. And the best way to do that is a narrowly crafted statute that gives permanence to these principles. You know, we've been debating this issue now for a decade, and everyone has more important work to do. Mr. Wheeler at the FCC has more important work to do, but he's going to spend a lot of time responding to requests here and litigation in court unless this issue is put to rest. So a decade into it now, it's time to settle it. This committee has within its ability the power to do that, and both of you have an incentive, both sides have an incentive to get it done, so I hope you will.
I want to go to Mr. Atkinson very, very quickly. Do you and the people you represent generally support what Chairman Walden and Chairman Upton have put out in draft form?
I would associate myself with Congressman Boucher's remarks. I think that it is in the right direction. I think there is room for compromise in it. I think the Democratic side has raised some points that have validity. So it's not a perfect bill in my view, but it's a very, very important first step, and it lays the groundwork for a legislative solution.
Thank you, and thank you, Mr. Chairman. I yield back.
Gentleman's time's expired. Now go to the gentleman from Pennsylvania, Mr. Doyle, for 5 minutes.
Thank you, Mr. Chairman, for holding this hearing, and thank you to all the witnesses, particularly my good friend and colleague, Rick Boucher. It's good to see you back here, Rick. I'm excited to see the FCC take this next step tomorrow in protecting an open Internet. I think the Chairman has recognized the passion and interest that people around the country have for this issue, and he's seen broad support from an array of stakeholders, from investors to venture capitalists to edge providers and ISP. Most recognize that the sky isn't falling, and many applaud the certainty that these rules will bring to the marketplace. You know, this morning I was checking the stock prices for many of the major telecom companies, and most companies' values were up. So clearly investors don't think the sky is falling either. Statements by executives by many of the nation's largest telecom companies reflect their expectation that these rules won't change their investment or deployment strategies, and that they believe properly crafted rules will not affect their businesses. I also want to point out that the FCC is also moving forward to grant a number of petitions by communities to lift restrictions on municipal broadband deployments. I think that is a great step in the right direction, and I think the communities can bring some much-needed competition to the broadband market. And finally, let me say, with regards to some of the concerns expressed by Ms. Blackburn, the Washington Post fact-checker looked at this study that she cites and completely debunked the study. The fact-checker said the more complex the issue, the easier it is for politicians to obfuscate the reality of the dramatic numbers, and our constituents deserve better than scare tactics that deliberately mislead the public, and gave it 3 Pinocchios. So I think that speaks to that issue. Mr. Kimmelman, I want to follow up on a question that Mr. Pallone asked you. This proposal by the White House sounds like it would severely undercut the FCC's authority to prevent ISPs from using their position in the marketplace to do things like charging subscribers not to have their browsing history data mined, or setting super cookies that allow users to be identified and tracked across the Internet. What benefit do you see in the FCC's ability to enforce privacy protections on ISPs, and what do you think would be lost if that authority was removed and vested in the FTC that may lack the authority to establish bright line rules the way the FCC could under Title II?
Mr. Doyle, I think it's a very serious concern if what you described is accurate. I think that consumers across the country rely upon the infrastructure of communications in this country to protect their privacy. It has historically done so. Section 222 has been used for that, and I think we need to look at that in the broadband environment. It would be extremely unfortunate if that were thrown out the window at this moment. I have a concern, just based on the characterization that you've provided, and Mr. Pallone, that the administration, which had been working on privacy legislation 4 years ago and had brought together many stakeholders, has pulled something out of the drawer and hasn't maybe fully looked at changes in the environment, including the regulatory environment, since those ideas were first floated. And I certainly hope that they are updating that and are listening to the concerns raised. This would be a very significant concern for consumers if all of a sudden they thought their privacy was in jeopardy.
Mr. Kimmelman, some have argued that paid prioritization and unencumbered zero rating of apps and services can be beneficial to consumers. Others say that these policies could lead to greater barriers to entry in the marketplace and, in fact, hurt consumers by limiting the array of new businesses and startups that can climb the paywalls that these policies erect. Where do you stand on that?
Mr. Doyle, I think paid prioritization can be extremely dangerous to the Internet ecosystem that we have today. I constantly think back to what Tim Berners-Lee has talked about as permissionless innovation. He didn't have to ask anyone to develop the World Wide Web. I think that's an important concept to keep in mind here. Now, having said that, that does not mean everything it's one size fits all, as Rob has said. It means there need to be important regulatory oversight functions applied as to what a particular service does, whether it's beneficial to the competitive process, whether it opens opportunities for innovators, whether it creates a new competitive option in the marketplace. So I wouldn't classify every service one way or the other, but in general, I think there should be a big alarm bell goes off when you see something that looks like paid prioritization as a starting point.
Thank you. Mr. Chairman, I'll yield back.
Gentleman yields back his time. I'd like to ask unanimous consent to submit in the record a letter from Mr. Mark Cuban. It says the market is aware of the uncertainty the FCC is creating and will respond accordingly by creating volatility. And a story in News Bay Media, Moffett downgrades cable sector on Title II woes. Without objection, those two items will be inserted in the record. I now turn to Mr. Olson. Are you sure it's not Mr. Shimkus, I believe, was here?
Sorry, sir.
Yeah, Mr. Shimkus, overriding my own counsel here for the next 5 minutes.
Thank you. It's great to be here. Great panel, great discussion, and again, it's good to see Rick here. Although his real name is Frederick Carlisle, goes by Rick, so I did my due diligence. Mr. Atkinson, given that Title II explicitly allows for discrimination, how can the FCC place an outright ban on paid prioritization?
Well, I disagree with this notion on paid prioritization. If we really want to ban paid prioritization, then we should ban CDNs, content delivery networks, that major companies like Netflix use. They're paying to get their traffic as close to the customer as possible. And a little Silicon Valley startup, maybe they can't pay for a CDN. So I think this notion that somehow some kind of paid prioritization is okay and some kind is not. Now, my position is we should let the market determine that. I actually think this could be really good for startups. There may be startups that can't afford to use CDN services. They may want to say, you know, I have an application that has what's engineers call low latency needs. The best efforts internet isn't going to do that. As long as the rule says that if you don't pay, you always get best efforts internet. We can never have a system where a carrier says you have to pay to get best efforts. So that's what any congressional rule has to say. But if you want to go beyond it, it's like I can get a 40-cent stamp or whatever it costs for the mail today, but if I want to go beyond it, as a business person, I have the right to get it. And I think that is very much pro-consumer and pro-business.
But that to have the certainty, that would require legislation. That would require language other than FCC, going to, the current Communications Act and then trying to wiggle in one section over the other.
Right, absolutely. And that's why we supported so strongly Chairman Wheeler's initial proposal, because he allowed paid prioritization, but he said it has to be reasonable, it has to be pro-consumer, and there's some safeguards around it. But he backed off from that position. I'm not sure why, but I think that was the right position, and guaranteed, the FTC goes forward tomorrow with Title II, you won't be able to have that level of customization.
I've been told to make sure I answer the same way. I'm not sure why, but I think I know why. So, Rick, you've looked at the European use of broadband, and it's obviously the different way of handling that. Obviously, the concern and part of this debate is that by moving into Title II, we may be falling into the same trap as the European community. Can you address that?
The Internet Innovation Alliance, with which I'm affiliated, did a study which we published about 3 weeks ago. The results of that are on the Alliance's website. And in that study, we took a close look at the broadband performance of Europe versus the United States. We did that in parallel to the regulatory structures that prevail in Europe and also in the U.S. In the U.S., we have historic light touch regulation going back about a decade now for broadband, and that light touch regulatory environment has been very welcoming to investment. In the European Union, for about the same period of time, going back to about 2002, they have had a more intrusive regulatory regime. Characteristic of their regime in most of the member states of the EU is something called unbundling and least access over the last mile. And that basically means that competitors are welcomed onto the incumbent's network at a set price, at a regulated rate. The history is pretty clear that in the European Union, that least access requirement has impeded investment. And on virtually every measure of Internet capability, the European Union is behind the United States, behind in access to broadband capabilities on the part of the public, behind in terms of speed, behind in investment on both the wired and wireless side, and even the European Commission has now concluded that the reason their performance is lagging is because of the intrusive regulatory structure that they have, and has recommended to the member states that for next generation networks, the fiber optic deployments, the gigabit level networks that are only now beginning to come to Europe, even though we have them more commonly in the U.S., that the member states should not apply the least access regime, saying that to do so would impede investment. So the simple conclusion we reach in our study is that at the very time when we appear to be moving now toward Europe in terms of a regulatory posture with Title II reclassification, Europe is now moving our way and lightening up its regulatory structure. Now, the FCC is proposing to forbear from imposing least access, but I'll be very surprised if Title II is adopted if you don't see some competitive carriers suing, saying that the FCC did not have an adequate record to undertake that level of forbearance, and saying that now that Title II applies, there has to be least access. Rob Atkinson earlier said that Title II is going to create a lot of uncertainty. This is yet another example of where I think it will.
Thank you. Gentlemen, time expired. We now go to Mr. Yarmouth for 5 minutes.
Thank you, Mr. Chairman. Rick, it's good to see you. Thanks to all the panelists. We've heard arguments that the FCC's net neutrality rules will make Internet speeds offered to American consumers as slow as those in Europe. But according to Akamai's most recent State of the Internet report, average U.S. Internet speeds rank behind what consumers can get in Moldova and 20 other countries. Address this to Mr. Kimmelman. Do you think that American broadband consumers are getting a good deal as compared to their European counterparts?
Thank you, Mr. Yarmouth. I think it's really hard to do apples-to-apples comparison of the U.S. and Europe. Some of their rules are European Union-wide, some of them are nation-specific, so it's a bit tricky. But in general, there are some policies they're imposing that are much more government-driven, that much more come out of a single provider monopoly environment, and they can keep prices low, and they can open up their platforms, and then they have other problems. And I think the better way to think about it is, can we do better here with our speeds and with our deployment? I think the answer is clearly yes. I don't think it's to follow a European model as such, and I don't think Title II is anywhere near the same as what most of the Europeans have done. But I think the goal of actually pushing up speeds, of reaching higher for what has now become this essential platform for economic and social growth in our society, absolutely yes, we should be pushing as hard as possible.
Some of your fellow panelists seem to take a different view of the current state of consumer choice in the American broadband market. I know in my district there's one provider that dominates the market. Essentially, that's the only game in town. So what is your view on the level of broadband competition our constituency currently enjoy?
I think there are a number of different measurements that are being used. The FCC is now pushing the envelope to really push for greater deployment. But by anything other than a snail's pace, we lack robust competition in our broadband market, particularly for the delivery of video quality services. And so often one provider, sometimes two. Mr. Barton, I guess, is fortunate to have more. Some people can use wireless for a variety of services, but usually not the most robust video delivery system. So we suffer from a very significant problem and lack of competition.
And what about the issue of cost versus quality and service? How do we rate in terms of what consumers pay for quality?
Again, I dare say anything too definitive because different countries have different rules, different frameworks. But there is no doubt there are some countries that have faster speeds and better quality. And I would just urge the committee to look at what are the policies that go with those to actually deliver that. Sometimes it's with greater government involvement, and that's something to actually consider as a matter of trade-off.
But just as a matter of principle, if you have one provider with very little regulation, then the odds of getting good service at a reasonable cost are lower than if you had either multiple providers in a vibrant competition or some kind of heavy-handed regulation.
Absolutely. And I'll just point out that going way back in history, we did have more of the open market that Mr. Atkinson was talking about, and it was bedlam. There was a refusal to interconnect in the early 1900s, which led to the development of the AT&T monopoly with a set of public obligations that came with it. So obviously a different time frame, but I just raised the admonition, the economics of that could still be problematic, that interconnection is not something that has traditionally worked well in a totally free market environment.
Great. Thank you, Mr. Chairman. I yield back.
Gentleman yields back the balance of his time. Chair now recognizes the gentleman from New Jersey, Mr. Lance, for 5 minutes.
Thank you, Mr. Chairman. Mr. Atkinson, in your testimony, you eschew the term net neutrality in favor of a more generic term, network policy. You say, and I quote, any network policy for the 21st century recognizes that the Internet is not inherently neutral, and that while some forms of traffic differentiation can be anti-consumer or stifle innovation, other forms may enable innovative new services. And I'd like you to elaborate. Perhaps that might be in healthcare or educational fields, but I ask for your expertise into how this could further innovation.
So I think one of the things that's been striking about this debate is the absence of the voice of network engineers. The Internet has never been neutral, and it's not neutral now. In the Internet engineering space, there are different priorities that network traffic receives because, frankly, if your email goes and you get it 50 milliseconds late, you don't notice and you don't care. But if your two-way video with your doctor is 50 milliseconds late, you basically cannot have that conversation with your doctor. 50 milliseconds is way too long. So the idea that we would treat all traffic the same is essentially an anti-consumer. It's going to stifle these kinds of innovations. If I could just make one quick point about the question on competition. We released a report last year called The Whole Picture, where we looked at competition. And using the OECD data, we have the third most competitive intermodal broadband market in the world. We're almost tied with Korea and Canada. We have more intermodal competition, in other words, 2 providers serving each home, than any other country. The reason there are a few countries ahead of us, like Japan, like Korea, is really 2 factors. They have very high population density. They're serving apartment buildings largely, super easy to do. And secondly, they've put in massive government subsidies. Now, we can have an argument about whether that's a good policy or a bad policy. But many of these countries have used public monies through tax incentives and grants. So this notion somehow that we are lagging behind because of the light touch regulation, I think is mistaken.
Thank you, and I appreciate that point. You cite in your testimony the almost certain legal challenges to the FCC's order and the uncertainty that would in turn create as evidence that a legislative route would be better than the FCC's reclassifying broadband under Title II. How long do you think the legal challenge would last if this were to occur?
I would imagine it would begin quite soon. And I would imagine, I would agree with Congressman Boucher, I think it's probably, you're talking 3, maybe 4 years before we would end up with any sign of real decision and certainty of whether this we can do a go or a no-go.
Thank you, and others on the panel are certainly willing.
Let me just
yes,
note
thank you,
that,
Congressman. Yes.
Just to look at the most recent decision in this space, it was the Verizon decision of the D.C. Circuit.
Yes, sir.
It invalidated the FCC's 2010 Open Internet Order.
Yes. Mm-hmm.
More than 3 years from the time the suit was filed until the decision was handed down. You know, my point is, that puts us into the next presidential administration. If there's a Republican FCC at that point, then network neutrality for all practical purposes is gone. There will no longer be network neutrality assurances. Those who strongly support network neutrality should be looking for greater permanence. A statutory alternative offers that.
And regarding the former case, did that go, sir, to the circuit court here at the D.C. Circuit? Yes. And, of course, in this situation, there's the potential that it could be appealed further and the Supreme Court might grant cert, and that would be an even longer period of time.
Yes.
Yes, thank you. Mr. Downs, you cite in your testimony how network management technologies could exist regarding oversight of the FCC. Do you believe that this will lead to reduced investment and innovation on the part of ISPs in broadband networks?
Well, it depends, I think, on how far the FCC goes now or in the future in terms of this public utility regime. Obviously, we have investment in our public utilities, including the wireline telephone network, but it's clearly not at the same pace and at the same froth level as what we have seen in the last 20 years under the light touch regime.
Thank you. And, Mr. Chairman, I yield back 16 seconds.
Gentleman yields back, balance of his time. The chair now recognizes Ms. DeGette next up.
Thank you, Mr. Chairman. You know, as a supporter of net neutrality, I've been glad to see that the latest debate has led to a consensus around principles of access to lawful content, no harmful discrimination, and transparency. These are really the core principles that have been laid out both in the Republican draft and also in Democratic proposals. And also the White House is in favor of this. And most importantly, maybe, it's what our constituents expect when they use the Internet. But, of course, the constituents expect much more than just an open Internet. They expect faster speeds, affordable prices, and access to new and innovative content. So for the last decades, the virtuous cycle of investment and innovation have given consumers these advantages as well. I know there's disagreement among the panel about the best way to implement net neutrality, but I want to step back to the core net neutrality principles, and I want to ask each member of this panel the same question. And this can be answered yes or no. Are the net neutrality principles of access to lawful content, no harmful discrimination and transparency if properly implemented, compatible with the continued investment necessary to give consumers the broadband experience they expect. Mr. Boucher?
Yes.
Mr. Kimmelman?
Absolutely, yes.
Mr. Atkinson? And Mr. Downs?
Yes, especially the way you framed it, yes.
Thank you. So I'm glad that we all agree that strong net neutrality can be an unambiguous win for consumers. Do you want me to ask this? Okay. Yeah, I'll yield. Well, let me ask one more question, then I'll yield to you if that's okay. Mr. Lujan has an excellent question that he wants to ask. Mr. Kimmelman, some have suggested that the power of the free market is sufficient to protect the open internet, but in your testimony you pointed out that some of the biggest ISPs have admitted there's a business advantage to violating open internet principles. Is this merely a theoretical concern, or have we seen cases of business actually trying to gain an advantage on their competitors by violating net neutrality principles?
We have seen examples, Ms. Teget. Fortunately, we've had rules in place, or we've had rules proposed for a long period of time that have very effectively disciplined most market behavior. And so we haven't seen a lot, but we have seen this, and it's very simple. It can be advantageous to the bottom line to favor one's own content, to favor one's own preferential relationships and content providers to make more money. And so there's nothing nefarious about it. It is a natural economic incentive for these ISPs to pursue such actions.
Thanks. Of course, Congressman Boucher, we all agreed up here after your testimony that we should just hire you as a mediator to work out this legislation. So I want to ask you, you said we need to have narrow bipartisan legislation, but you single out the network neutrality principles as a key non-negotiable element. So why do you think the debate has moved past negotiations over network neutrality principles?
I think very simply because both sides now have quite a bit of leverage. And when both sides have leverage, roughly equal, and I think that's the situation today, it is the optimal circumstance for legislating. There are two key principles that really matter here. And the first of these is that the Republican offer for embedding strong network neutrality principles in the statute be accepted by Democrats. In return for that, we ought to be continuing to treat broadband by the proven method, and that is an information service subject to Title I with light regulation. We've had that for a decade, and we've developed the most capable Internet by virtually every measure that exists anywhere in the world. If you add all of our ecosystem of the Internet together, it is the envy of the world. Let's don't upset that very workable formula. Keep Title I in place. Those are the two key principles of legislation.
Thanks.
And I think the fact that Republicans have moved as far toward the Democratic position as they have is really a major development. It's noteworthy, and it's because of the leverage the Democrats now have as a consequence of the reclassification decision.
Thanks. And I'll yield the balance of my time for a follow-up to Mr. Lujan.
Thank you very much. I thank the lady from Colorado. Mr. Atkinson, something that you said earlier caught my attention. You said in regards to Mr. Boucher that Mr. Boucher had valid issues regarding the Republican discussion draft. Can you expand on that?
Well, I'm not in a position to go into a significant amount of detail, but I think there's two key points there. One is there are valid issues because there are no Democrats who supported that, and so you cannot get this bill passed with the president signing it unless there's some compromise. So I think that's point number one. Point number two is the FCC. I think the bill could go slightly farther with the FCC, giving the FCC some authority. Now, what I think the bill rightly does is under 706, for example, there's unlimited authority. 706, you can use that to justify pretty much anything, and that's clearly too broad, and it was clearly too broad when it was passed in '96. So there needs to be some constraints on the FCC, in our view, but there needs to also, at the same time, they need some abilities to be able to go out and effectively police issues.
If I may, Mr. Lujan, since you were asking about my thoughts, and if the chair will just indulge me for a moment, I'm going to take issue a little bit with what Mr. Atkinson just said about 706. I did note at the outset that I had some issues with the Republican draft. I'm going to be very candid to say that I think when the draft suggests that Section 706 not be deemed an affirmative grant of authority to the FCC. That does go too far. And that is not a necessary provision in order either to assure that we have strong network neutrality principles in the statute or to continue the light touch regulatory treatment that broadband enjoys today. So as a starting point, while Democrats sit down with Republicans to negotiate an agreeable statutory formulation, I would hope Republicans would say, you know, that does go fairly far. We acknowledge your concerns. We're willing to take that provision out. To me, that would be a sensible step to take.
Gentlelady's time has expired, and we appreciate the comments from the former member and former chairman. At least we're having those discussions with you. Mr. Collins, for 5 minutes.
I want to thank the witnesses today. It seems as though the discussion now is moved from net neutrality to Title II, because we have all coalesced around the concept of net neutrality. So, Mr. Atkinson, you brought up the point that you're fairly certain litigation is the next step, absent congressional legislation. I think I heard Mr. Downs say that could be 2+ years. So I'm a private sector guy, an entrepreneur. You make investments based on as much certainty as you can get. That's kind of just a rhetorical statement. And as you introduce uncertainty, with uncertainty, it doesn't mean it's all or nothing. Some would say, well, isn't there going to be investment? Well, sure there is. But the more investment, I think, the better to certainly rural broadband and the others. We want more investment, not less. It's my belief as a private sector guy, uncertainty brings less investment than certainty. And as I now look at where we are with the upcoming rule as we understand it from the FCC, it's disappointing to say the least that the FCC and what they're going to do relative to Title II, the consequences of what I'd call that overreach will be uncertainty. And with that, less investment than otherwise. Doesn't mean no investment, but less investment. And that's not a good thing, which is why I think I'm very happy to hear a lot of consensus. It is the role of Congress to push forth a bill. If we do so, we do it in a bipartisan way. That should trump what the FCC is going to do. And so, Mr. Atkinson, I'd like to talk a little more about the litigation piece, where you see it coming, how quickly you see it coming, and if you agree with me that in an arena of litigation, absent something else, there'll be less investment than more.
I do agree with you. It won't be catastrophic, but at the margin, there will be likely less investment if we go down this path. I also would like to point out the uncertainty really, I think, is for both sides on this debate. I mean, there's a legitimate argument, I think, that the advocates of net neutrality make that Silicon Valley entrepreneurs or other entrepreneurs, they need some level of certainty about, are they going to, maybe 5 years from now, carriers do this? Totally agree with that. Carriers need certainty. My concern with Title II and what the Commission is doing is that it really is not providing certainty. It's providing certainty in a way for maybe a year or 2 or 3. But don't forget we have an election coming up. And let's say, just say for the hypothetical, 50-50 chance. That means you have a 50-50 chance that you're not going to have any rules. And agree with you on the legal challenges. I think what we'll see is, as Mr. Downs said, rent seeking from particular carriers with particular interests or other groups who go in and say, you know what, we can gain a slight advantage over our competitors if we challenge the FCC on this particular component. And that's perfectly reasonable for them to do. It just will gum up the entire process.
Now, as I understand it, there's something around 1,000 provisions in Title II. And we've heard rumors anyway that they're going to forbear on this one, and another one. Maybe forbear on the ROI as we limit returns on electric utilities. True monopolies, that they would forbear on that piece, which would be the death of the Internet if they decided the rate of return could be 6% or something like that. But with 1,000 provisions, and we don't know which ones they'll forbear on or not, isn't it also in the uncertainty realm, once they have Title II, they forbear now, a year from now, 2 years from now, a different president, they decide not to forbear. So I'll go back again. I'm encouraged to hear, I think, almost a coalescing. We need congressional legislation on net neutrality. Title II is just a wet blanket on it, and perhaps that's part of the incentive that's brought us together. Well, let's not question that. We are, I think, more together than not. But especially, would you agree that those 1,000 provisions, and forbearing or not, is really what's going to have this gummed up?
I would definitely agree with that this is going to provide anything but certainty.
Mr. Downs, any comments in our last 30 seconds?
Yeah, so I agree with Mr. Atkinson, and as I say, I'm just baffled by the chairman's decision here because, as he himself said, when the D.C. Circuit ruled in the Verizon case, it provided him a roadmap and an invitation to reenact the 2010 rules under Section 706. It was, certainly not without legal risk, but certainly nothing compared to the legal risk now of Title II and all the forbearance proceedings that will go with it.
Right. Well, I want to thank all the panel today. I yield back, Mr. Chairman, my last 10 seconds.
Gentleman yields back the balance of his time, and now we turn to the gentleman from Illinois, Mr. Rush, for 5 minutes.
I want to thank you, Mr. Chairman. Mr. Chairman, I have been involved in another hearing, joint subcommittee hearing downstairs, and so I have not been able to participate as fully as I would like, but the time that I've been here, this has been quite interesting to me, and I certainly want to take a moment to join in with the course of welcoming our esteemed colleague, Chairman Boucher, back again. Rick, your time on this subcommittee where I served with you was really an era of enlightenment for me. So I really want to thank you so much for your contributions. And I wish that we were spending as much time on reforming program carriage rules as we are on these issues that we are discussing, net neutrality and associated issues. Reforming carriage rules, especially as it relates to independent networks. I think that's something we need to get to. That said, a free and open internet with unfiltered access is what I believe we all want. You believe that Title II reclassification is not a viable solution in addressing net neutrality. Rick, in your years as chairman of this subcommittee, do you really believe that the FCC will be able to forbear all of the onerous provisions of Title II?
Thank you very much, Mr. Rush, and thank you for your kind words and your words of welcome as I return to the committee to offer some views. I think it's challenging for the FCC to undertake forbearance without the development of a complete record that justifies each of the forbearance steps. And the FCC's record in developing its forbearance decisions is really pretty thin. My guess, and I'm just guessing, is that a lot of the basis of the litigation that's going to be upcoming is going to be challenging the absence of an adequate record for the FCC to take its various actions in association with this reclassification, forbearance among those actions. So the short answer to your question is, I think Chairman Wheeler is trying to forbear from the most onerous provisions of Title II, such as tariffing requirements, rate regulation, leased access, and unbundling. He's making a serious effort to do that. I think his decision to do that is going to be significantly challenged in court, and we don't know what the outcome can be. Coming back to my core point today, that's yet another reason that it's in the interest of everyone to use this moment to provide permanent protection for network neutrality, to do so in a statute, and also in that statute continue the light touch Title I treatment that has been so successful here for the last decade.
You point out that the Republican discussion draft would codify transparency requirements and prohibit blocking, throttling, and paid prioritization. What is your position on including a ban on zero rating practices?
I'm going to forego dissecting the legislative draft in any detail because I think that's uniquely the responsibility of the subcommittee, and there are clearly provisions in the legislative draft that ought to be open to discussion and negotiation, as long as in the end what is achieved is the embedding of network neutrality principles and light touch regulation, this subcommittee will perform a great service. So I would leave to the bipartisan conversation a discussion of the specific elements that are in the draft legislation.
I appreciate the gentleman yielding the remainder of his time. I think it's very important to raise the issue when it comes to legislation that there not be an automatic assumption that because there's the recognition that these three items are mentioned in the bill, that they are automatically banned. There are problems in the legislation because there is no follow-up by the agency that has jurisdiction. In fact, the agency is prohibited on behalf of the American people to implement these so-called prohibitions. So there is a distance to go. And this really needs to be addressed if there's ever any hope. And no one has raised this from the panel, and it's a very important item, I think, for all of us to know. And there was something raised earlier about thousands of things in Title II. There are actually, 47 sections in Title II, with only a handful that, in my view, need to be used relative to the regulations. Mr. Chairman, I'd like to ask for unanimous consent to submit a letter for the record from the Internet Freedom Business Alliance that supports the action the FCC is taking tomorrow on net neutrality.
Of course, without any objection.
Thank you very much.
Yep. And I must just respond to my colleague. There are actually exactly 1,000 provisions within the CFRs. That's where the rules are. That's the reference I believe Mr. Collins was making. And as for our draft legislation, the FCC would have complete and total enforcement capability to enforce the law. And so I would disagree with the characterization by my colleague. And I would ask unanimous consent to submit for the record a number of items, including a story quoting the Chief Operating Officer, Mike Sievert of T-Mobile, where he says, while there's nothing in there that gives us deep concern about our ability to continue executing our strategy, he said the reclassification is not the most desirable approach, without objection. We have a series of documents concerned with the partisan Title II approach, including editorial from the Washington Post, letter signed by Mark Cuban and others, to the Commission. Some other publications here I think have been shared with the minority, and without objection those will be in. We have some documents regarding people's views affecting small business from Barbara Espin, Counsel for the American Cable Association, and ex parte that we would submit for the record. Consumer impact, I believe, is the next one from the Progressive Policy Institute, that as much as $11 billion per year might be put on consumers' backs as a result of Title II reclassification. And we have information for the record regarding successful U.S. approach with European history with the approach the FCC plans to take, a number of articles and statements. And I think that is the bulk of our submissions for the record. Without objection, they will be submitted as well. We thank our witnesses for your clarity to this issue and for your sharing your comments. We look forward to seeing what the Commission does, and eventually actually having the opportunity to read the 332 alleged pages of whatever it is they're going to vote on tomorrow. So with that, the committee stands adjourned.